next matter to come before us this morning is Andrea L. Wenger versus Hollin, Carrie Wenger. Each party will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. I'll be keeping track of the time. You can also reference it on the wall. But if you let me know how much time you'd like, if any, to reserve for rebuttal, I can let you know when you're reaching into that reserved time. The arguments are being recorded. They will be posted on the court's YouTube channel. Please don't use the name of victims or minors. For that reason, I don't know that that's all that relevant in this case, but we'd like to make that advisement. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. May it please the court. My name is Leslie Kransky, and I'm here on behalf of Andrea Wenger, who was a wife of over 30 years at the time of the decree in this matter. This matter was heard by a magistrate. Ms. Wenger filed objections, and the trial court issued a very brief decision with utterly no analysis or independent review of the magistrate's decision or the objections. The award of spousal support is unfair because it is a 31-year marriage. The wife had helped the husband with his education. They had lived in Florida. She was working, he was working. They weren't making much money, but he had a dream of being a law enforcement officer. So they moved back to Ohio, and she helped him go to Walsh University and get his credentials. He is now making over $80,000 a year most years, and she is earning $17,000. After they returned home, she stayed at home with 2 children, and that was recognized in the magistrate's decision before the decision found that she should receive only $1,000 a month in support. The record shows that husband admitted that he was often away 80 to 90 hours during the week when she's home taking care of the children. She had no opportunity to work a job and accrue retirement as he was doing. The wife did not work in her field of photography after they returned home. This is recognized in the magistrate's decision and then ignored in the finding of an award of spousal support. The wife earns $17,000 a year. The husband earns approximately $80,000. Some years a little bit more, but always close to the 80. The record shows that husband deposits more than $17,000 a year, his wife's salary, into his retirement account every year. And yet, the court granted the wife only $1,000 a month in spousal support. Wife is really in a box because while they are together, and this is the contract, she took public employment, which gives her public retirement, which means that her Social Security fundamentally disappears because of her public retirement. If she left her job, she's not horribly well skilled, and went to a Social Security job, she loses what she has accrued in state retirement. Her Social Security is about $500 a month. It's a little bit less than half of what she could claim, a little bit more than half of what she could claim through her husband before the windfall hits. The wife has no health insurance benefits. The husband has free health insurance.
Was there any testimony from wife on what it might cost her for health insurance?
Yes, there was. It was between $735 and $893 a month. The temporary order, I might note, was $1,650 per month when she had free insurance. So the magistrate's decision took away that $650 and put $735 to $893 on the wife's head in its place, and leaves him with $80,000. The retirement is really significant because he's putting more than her salary away for his retirement, and she's getting retirement based on a $17,000 salary. So he's getting retirement based on an $80,000 salary post-division. I recognize that she's going to get a share of his marital portion, but everything after that is gravy for him.
Did the wife at trial make some request for a specific amount of support or a duration of support?
Yes, she asked for $2,000 a month in her objections, which I think was a lowball offer.
In her objection, at the trial, had she made a specific request,
I
within a
believe-
trial brief or?
I don't know.
Okay.
I won't represent that. I would
Fair
suspect
enough.
that her attorney did because he was very clear in his objections. I think he may have focused on equalizing at trial, but I don't want to say I know something that I don't know. Wife is tied to this low-level employment by the Windfall Reduction Act. She's tied to low-level employment because she doesn't have a lot of skills. There's no commercial photography jobs out there. Husband, I'm sure, will say that he has to retire when he's 60, but the record shows that he's eligible for other employment when he's 60, which will likely have retirement options, but his spousal support will end. And she will be there at $17,000, maybe with cost of living adjustments, and will never retire because she'll never be able to afford to retire. This decision was just unfair, and the trial court didn't even look at the objections filed by the wife.
Well, how do we know that, though?
We know that because there's one paragraph saying, we've read the wife's objection, we disagree with them, and we adopt the magistrate's decision in its entirety. That's all that's there.
Right, but I understand that, but I guess what I'm asking is, just because the court didn't write specific reasons and deal with them each individually doesn't mean that the court didn't do that. It said on the order that it had done that.
It says that we've looked at the objection, and this court has rejected many court decisions that don't independently review, where this court doesn't see any sort of independent review of the magistrate's decision there. This is not a lonely decision. Hold on a second, let me find some more on that piece. The court must independently review the record and make its own factual and legal findings. We read the objections, we don't like them. We're adopting the magistrate's decision as a whole. It's not making its own factual and legal findings. The court may rely on the magistrate's credibility determination because the magistrate is there observing the witnesses and the court is not. However, the court is required to make an independent factual and legal findings in its decision. That's, I don't know how to say it, but I'm going to try Giglio versus Giglio, that's 3rd District. This court has recognized in Panhorst versus Panhorst, the trial court needs to give sufficient information and to reach a legal conclusion on its own. That's Panhorst, which is cited in my brief. This is a very long-term marriage. The wife stayed home and raised children while the husband pursued his dream career. That was the contract. That's not, she's not here complaining about that, but she's saying when you're done with me now, after 31 years, you shouldn't be supporting your fiance, who the record demonstrates was living with husband, and she was able to go from full-time to part-time because he was there. So he had funds to take care of his fiance, but the magistrate did not find, and the trial court, more importantly, did not find that he should contribute to the support of his wife. It's also terminable at 8 years. So he'll be 60 years old, qualified for all sorts of sheriff duties, all kinds of law enforcement duties, and he will have no spousal support obligation, and the wife will work until she dies. For these reasons, we would ask that the court reverse this decision and remand it to the trial court.
Go.
No, just before you
Sorry.
conclude, no, you're fine. Before you conclude, I just wanted to ask how much, I understand that your argument was wife was compelled, but how much did the fact that she lived with somebody else enter into the equation?
Well, if you look at the actual facts, she's living with someone else because She had $1,600 a month in spousal support, which added to her $17,000 a year, still puts her way under husband income-wise. She couldn't afford to live without a roommate. She's not engaged to her roommate. He's engaged to his. He takes trips with his immediately prior to trial. She gets to quit working full-time prior to trial, the girlfriend does. And wife is left on her own. But yeah, it's different. I mean, she has a roommate, she does. But she wouldn't be able to keep her lips out of the water without a roommate, and the record shows that.
So, I'm sorry.
Please don't follow.
So you're not necessarily saying it's cohabitation?
Oh, I don't think it's cohabitation on her side. I think it would have been cohabitation on his side, because you go through the whole analysis. Is it fair for an obligor to give money to someone who's supporting someone else? Well, it's sort of the obverse, not the reverse, but the obverse of that argument, because he has enough money to support another woman and not his wife of 31 years. Boy, you took me back to the Aristotelian rectangle from logic class. My gosh. Did that take care of you, Your
Yes.
Honor?
Thank you so much.
Remind me of the factors of spousal support, I apologize. Are one of the factors the court is able to consider if a party is sharing expenses with another person in their
That's not actually one of the statutory factors. I'm sure it would come under any other factors
That
at
would
the
be,
end.
there's not a specific factor for that.
It's not a
It could be
specific
considered
factor
the
under
catch-all.
spousal support. It's one that this court has considered regularly when it looks at cohabitation.
And are you asserting that the issue before us is a standard review of abuse of discretion in this case as to your second assignment of error?
Yes.
Thank you.
Thank you very much.
Thank you, counsel. You'll have just under 4 minutes for rebuttal.
Thank you very much, Your Honor.
Good morning. My name is Benny Miller. I'm an attorney for the husband in this case. I would like to point out to the court that the trial court did specifically indicate that it had conducted an independent review of spousal support issues. The order specifically says the plaintiff has filed objections to the magistrate's decision filed September 20th, 2022. Having read the plaintiff's objections to the magistrate's decision and the transcript of the proceedings, the court finds that it's not well taken and is hereby overruled. The court then goes on to say that it's ordered to judge and decree that the plaintiff's objections to the magistrate's decision are overruled. It's further ordered to judge and decree that the court adheres to its decision dated September 20th, 2022. There's nothing in the record that indicates that the trial court did not conduct an independent review of this matter. Wife may not be happy with the decision, but that doesn't mean that the trial court did not conduct an independent analysis. And that's the basis for the first.
What about the cases cited by appellant in this case? I think Pam Horsham mentioned maybe Carmichael, and those cases indicate the court must make more than just conclusory statements, if you will. I've looked at this and it's all okay, but have to engage some kind of fact finding of their own.
I think what the court did is they specifically said, I am affirming the original judgment entry that I entered in the case, which has a detailed analysis of the factors listed under the spousal support statute.
As I recall in this case, that was a typical magistrate approval where the decision comes out and the magistrate and the judge approves at the same date? Is that fair?
I'm not sure if it was the same day or not, but it was close in time,
Okay.
and they generally are.
Right.
But again, that doesn't mean that there was an independent analysis. And White hasn't provided this court any facts to support that. What White is basically arguing is that the trial court didn't do what the trial court said it did, which is without any facts is pretty difficult thing to do, I think.
Well, I would just ask you, on its face, it does seem a little unfair, doesn't it? 31 years and she's only earning $17,000 a year?
I think if the court takes a look at the overall situation of this couple, not really. I mean, there was a substantial order of support in my mind. 8 years, $1,000 a month is $96,000. He was also, the husband also paid all the bills prior to the divorce, leading up to the divorce when they separated. She had $1,000 that she was basically free and clear because all the bills were being paid for by husband. And then when temporary support at $1,650, she was basically had a salary for a period of time, $2,650, that she could do with as she pleased. Despite that, she ran up some huge debts. I think there's mentioned in the magistrate's proposed decision that she had a problem basically staying within her budget, and that had been an issue throughout the marriage. So I don't think necessarily in that respect, because I think the parties were always in trouble with their budget. If the court looks at the decision, the parties didn't have really any substantial assets beyond their income. The only asset they had was their home, which there's $12,000 something in equity in that home, and that was awarded to mother. So the court went through the analysis of spousal support and went over all of the factors that go into making a decision on spousal support. But it was done last after the assets have been divided, and the court gave more of those assets to wife. And it was a long marriage. I mean, it was over 30 years. But they married young. These individuals are not old. They're not on the verge of retiring. And I think there's a rationale for not having people connected forever. But wife is not left without any recourse. I mean, the court continued jurisdiction of both the length of support and the amount of support. So she does have remedies. But I do not believe that it was unfair. I think the court took a look at the factors and decided that these people had not saved much of anything. And there's nothing preventing wife from taking steps to be able to generate more income.
How old are the parties?
Early 50s, I think at the time this was right, is 51 and 50 or 52 and 51 in that range.
Did the party divide did the court divide the party's debt equally? Do you know?
No, they did not. They held her specifically responsible for amounts that were run up during the separation.
So she was ordered to pay more debt than husband was ordered.
Correct.
As far as the asset and liability factor.
Yes.
Do we know what the difference is in how much debt wife left the marriage with and husband left? Do you recall from the facts of the case?
I do not recall.
Would that be somewhere in the court decision if we go through that?
Pardon?
That would be somewhere in the court decision if we go through the court decision, but since you were focused on spousal support, you weren't focused on that portion, understood?
Correct. And the court did that because, according to the magistrate's proposed decision, which was adopted, there was no reason why mother should have run up that amount of debt. She also had a $30,000 inheritance during this period of time. All that money was gone by the time of the...
That would have been her separate property, however. Had she not spent it, it clearly would have been her separate property.
Absolutely.
And as I understood it, recall the court's decision, there was a clear review of all the factors.
Yes.
An analysis of each factor.
Yes.
But then no overall discussion of how those factors had any interplay as to why the court picked $1,000 a month.
There was just a conclusion as to what it decided the appropriate amount was.
Was there any explanation as to why the court felt this was a case would have a term of years rather than a lifetime support or the.
I viewed it as because of the age of the parties.
But they didn't specifically say that to your
No,
recollection?
they did not. Not that I recall. But, as I said, I believe that the court was clear that it did review these, that it did go over all the factors, that it looked at the transcript, that after doing all that, and considering all the factors, it was not swayed to change its original judgment entry. And I believe that the order with respect to spousal support, certainly not an abuse of discretion. The court retained jurisdiction both to amount and the term of that. So I don't believe that this reaches the level of an abuse of discretion. So it'd be our position that the court should affirm the trial court's decision in this matter. Are there any further questions?
Seeing none, thank you, counsel.
Thank you.
May it please the court, it would make me very happy if this court found that the trial court did not err in its conclusory adoption of the magistrate's decision, because I would like this court to look at the statutory factors and the inherent unfairness here. The husband will be accruing the wife's salary every year towards his retirement for the 8 years that she's receiving all of $1,000 a month in spousal support. You know, the court may retain jurisdiction, but what more has to happen to this woman's life for the court to think she could have a little bit more money? You know, if the school closes and she ends up unemployed, now she's got nothing except unemployment compensation, and what is the court going to do? Lift her up to where she would be if she had her $1,000 a month and her $70,000 a month? Well, he is making $80,000 a year. And
So before we go any further, I just need to ask you one more question, I think. In regard to, you just said nothing would make you happier than for us to look at the merits of this case and reverse, or say it's the abuse of discretion, whatever. So are you saying the only thing you're arguing are procedural issues, that you're not asking us to look at the merits?
I would like this court to look at the merits. I felt like I needed to show the things that had gone wrong in the trial court. But if this court says what the trial court did was enough, then we can go to the merits, and we can look at what this wife contributed to this marriage, what she is living on, what he is living on, what her expenses will be, and how they increase by almost the entirety of her spousal support obligation just to have health insurance that the husband has for free. The arithmetic in this case is just astoundingly inequitable. And I read the transcript, and I read the decision, and I read them again, and I don't know, the wife took her inheritance and got herself a car, replaced her car. You know, we know how much that cost. She spent her separate property. She went into some debt because they had lived at this level and she didn't manage her money great. But you don't punish someone by saying he gets $80,000 and you get 17 plus 12. You don't punish parties with spousal support. You don't even punish the husband for getting engaged, buying his girlfriend a ring while he's still married, taking her on a trip, and letting her cut back her hours, and he can support her. This is not about punishment. This is about equity.
In dealing and discussing spousal support and the factors, out of curiosity, do you recall if at any point in the factors the court considered the new relationships for each of these parties?
I don't think the magistrate...
I know it's part, there are other parts of it, but was it involved in the spousal
I
support?
don't think there's any direct application of
It's not under Dan or any other factors that you recall where the court discussed?
I don't think so.
Do you recall what the division for the debt was? I know wife got $12,000 in assets, the only thing they had.
Yeah,
Do you
it
recall
wasn't that much. And I know she was ordered to pay the debt she incurred during the course of the temporary orders and in the period before temporary orders were enforced, because we know that, you know, if you have nothing coming in, there's a lot of expenses involved there. So this was just a significant punishment, and I don't think this court would affirm punishment as the keystone to an award of spousal support.
I know you're out of time, but I'm going to ask one more question real quick. You say that, you know, she didn't have all this income coming in and everything when they were in their separation period before the divorce, but he is saying, the other side is saying that husband paid all the bills, so she didn't have any expenses.
She did have expenses, the record shows she had other expenses, yeah.
So he did
He
pay.
paid the mortgage,
Okay.
so in essence, her temporary orders was way more than $1,650 because it was housing plus $1,650. So this is just an astounding reduction in support to a woman who has been married for 31 years, raised children, et cetera, et cetera.
Was there an explanation as to why the reduction from 1,650 to 1,000 in the court's decision?
I don't think so. I think it was a determination that that was an appropriate and necessary, when it was a statutory language spousal support award.
Thank you, Counsel.
Thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties in this appeal by the clerk of courts on the day that it is issued. You may also check out House Supreme Court website as our opinions are posted there. Thank you again.
Thank you.